Imagine a scenario where the lines between state and federal authority blur, where governors stand firm against the president's command, and where the very notion of a state's independent guard is challenged. Today, we're diving into a political firestorm that ignited when President Donald Trump, during a campaign rally, issued a provocative threat to deploy California's National Guard to the streets of Portland, Oregon, and Texas's National Guard to Chicago, Illinois. This isn't just a political soundbite. It's a profound legal and constitutional debate that raises critical questions about federalism, state sovereignty, and the role of the National Guard. What happens when a president demands the impossible? And how do states respond when their autonomy is on the line? Stay tuned as we dissect this unprecedented controversy and explore its far-reaching implications. The spark, a president's provocative rhetoric. The genesis of this cross-state controversy lies in the heated rhetoric of a political rally. During a campaign stop, the former president, known for his unvarnished and often confrontational communication style, made statements that sent shockwaves through state capitals and legal circles alike. He asserted that if elected, he would utilize the National Guard forces of states like California and Texas to address issues in other, often Democrat-led, cities such as Portland and Chicago. The context of these threats was invariably framed around urban crime rates, civil unrest, or perceived failures of local governance, topics frequently emphasized in his campaign messaging. For example, his specific mention of Portland often harked back to sustained protests and clashes that occurred there during 2020, while Chicago was repeatedly cited due to its well-documented struggles with gun violence. These statements were not off-the-cuff remarks. They were delivered with a declarative tone, implying a clear intent to execute such a strategy. This immediately sparked a furious debate, not just among political commentators, but crucially, among legal scholars and state officials who understood the intricate legal framework governing the National Guard. The core of the immediate reaction was disbelief and confusion. Could a president actually do this? And if so, what would be the implications for the delicate balance of power between the federal government and individual states? The controversy thus began as a clash of words, but quickly escalated into a significant constitutional discussion, drawing attention to the often misunderstood nature of the National Guard's command structure. The National Guard, a dual identity. To fully grasp the magnitude of Trump's threats, it's essential to understand the unique, dual nature of the National Guard. Unlike the regular active duty military, which falls solely under federal command, the National Guard operates with a foot in both worlds. Primarily, the Guard units are state militias organized and commanded by the governors of their respective states. When called to state active duty, they respond to local emergencies like natural disasters, think hurricanes in Florida or wildfires in California, or assist in maintaining public order, always under the direct authority of the governor. This is their state mission, deeply rooted in the concept of state sovereignty and the 10th Amendment. However, the National Guard also has a federal mission. When authorized by Congress or, in times of national emergency, by the President, Guard units can be federalized. This means they are temporarily removed from state control and become part of the active duty military, falling under the command of the President. During federalization, they can be deployed anywhere in the world, just like any other military unit. Examples include deployments to combat zones or responses to national crises, like the September 11th attacks. The crucial distinction lies in who initiates the deployment and for what purpose. A governor deploys their state's guard for state-specific needs. The president federalizes them for national needs. The units, while equipped and often trained to federal standards, remain distinct from the active military in their day-to-day operations and chain of command. This dual status is the bedrock of the entire controversy, as Trump's threats seem to bypass the state command structure entirely, implying a federal takeover of state resources for non-federalized purpose. Governors push back, a constitutional showdown. The reactions from the governors of the targeted states, California and Texas, were swift, unequivocal, and fiercely defensive of their state sovereignty. Governor Gavin Newsom of California and Governor Greg Abbott of Texas, despite their differing political affiliations, Newsom a Democrat, Abbott a Republican, found common ground in rejecting the premise of Trump's statements. Both governors made it clear that their state's National Guard units serve their states, under their command and would not be deployed to other states against their will, especially not at the directive of a federal executive acting outside the established legal framework for federalization. Governor Newsom explicitly stated that the California Guard is accountable to California citizens and would not be used as a political tool. Governor Abbott, while generally aligned with Trump ideologically, also emphasized the independence of the Texas National Guard, underscoring that its deployment decisions rest solely with the governor of Texas. Their arguments were firmly rooted in the constitutional principle of federalism, which delineates powers between the federal government and state governments. They cited legal precedents and the specific language of the National Guard Act, which governs the conditions under which the Guard can be called into federal service. The resistance from these governors wasn't just political posturing. It was a strong assertion of state rights, signaling a constitutional showdown should such a threat ever be acted upon. The essence of their pushback was simple. The National Guard is a state asset, and its deployment without the governor's consent for a non-federalized mission constitutes an overreach of presidential power. Legal limbo. Can President do that? This brings us to the core legal question. Could President truly bypass state authority and unilaterally deploy a state's National Guard to another state? The short answer, according to most constitutional scholars and legal experts, is a resounding no, at least not without first federalizing them. The Insurrection Act allows the president to deploy federal troops and federalize National Guard units within the United States to suppress insurrections or enforce federal law when states are unable or unwilling to do so. However, the crucial step here is federalization. Once a unit is federalized, it ceases to be under the governor's command and falls under the president's. The president cannot simply transfer a state's National Guard unit, still under state command, to another state without the consent of both the sending and receiving governors. Legal experts highlight that the president's power over the National Guard as a state militia is extremely limited. He can call them into federal service, but he cannot dictate their deployment while they remain under state command. The threat to send the California Guard to Portland or the Texas Guard to Chicago while they remained under their respective governors' commands would be an unprecedented constitutional crisis. It would represent a direct challenge to the dual state system and likely trigger immediate legal challenges from the affected states, potentially leading to Supreme Court intervention. The legal consensus is that while the president has significant powers, unilaterally commandeering state-controlled militias for interstate deployment without federalization or state consent falls outside the established constitutional and statutory frameworks. Historical precedents and future implications. While the specific scenario of a president forcing one state's guard into another without federalization is largely unprecedented, history offers some parallels concerning federal-state clashes over military force. During the Civil Rights era, presidents sometimes federalized National Guard units or deployed federal troops to ensure desegregation, often against the will of state governors. For instance, President Eisenhower federalized the Arkansas National Guard in 1957 to enforce court-ordered desegregation at Little Rock Central High School, directly overriding Governor Orville Faubus. However, these actions were taken under clear authority of federal law and involved federalizing the Guard, not simply redirecting state-commanded forces. Another relevant historical context is the debate around governors deploying their Guard units across state lines to assist other states with emergencies, such as natural disasters. This is common practice, but always happens with the explicit request and consent of the receiving state's governor and the agreement of the sending state's governor. This demonstrates the respect for state sovereignty inherent in such deployments. The implications of Trump's threats, if ever acted upon, would be profound and destabilizing. Firstly, it would set a dangerous precedent for federal overreach, eroding the concept of state sovereignty and federalism. It would effectively turn state National Guard units into a readily transferable federal asset, undermining their primary role as state militias. Secondly, it could lead to widespread civil disobedience and legal battles, creating a crisis of legitimacy for both state and federal authorities. Thirdly, it could politicize the National Guard to an unprecedented degree, potentially damaging public trust in an institution designed to serve communities impartially. Such a move would undoubtedly be met with fierce resistance from state legislatures, governors, and potentially even within the Guard ranks themselves, leading to a constitutional stalemate that could have long-lasting repercussions on the balance of power in the United States. The controversy, therefore, serves as a stark reminder of the delicate constitutional architecture that governs the relationship between Washington, D.C. and the 50 states, and the constant need to uphold it. The bigger picture, federalism under strain. The cross-state controversy transcends the immediate headlines, revealing deeper tensions in American federalism. At its heart, this debate is about who holds ultimate authority over armed forces within a state's borders and under what conditions. It highlights the ongoing struggle between federal power, intended to ensure national unity and enforce federal law, and state power, designed to protect local autonomy and respond to unique state needs. The rhetoric employed by President Donald Trump, suggesting the ability to simply command state forces at will, strikes at the very foundation of this carefully constructed balance. It forces a national conversation about the limits of presidential power, especially concerning domestic military deployments. In an era of increasing political polarization, such threats can be seen as attempts to centralize power, bypassing local governance, and potentially exacerbating existing divisions. The unwavering pushback from governors, regardless of party, underscores a bipartisan commitment to preserving state prerogatives against perceived federal overreach. This controversy serves as a crucial case study, illustrating how fundamental constitutional principles can be tested by political rhetoric and how the response of state leaders can act as a vital check on potential abuses of power, ultimately reinforcing the enduring importance of federalism in the American system of governance. Conclusion: a reminder of constitutional boundaries. In conclusion, the threats made by President Donald Trump to deploy California's National Guard to Portland and Texas's Guard to Chicago ignited a critical constitutional debate. While the president has the power to federalize National Guard units and deploy them as federal troops, he cannot simply commandeer state-controlled Guard units and transfer them across state lines against the will of their respective governors. Such an action would directly violate the principle of federalism and the dual nature of the National Guard's command structure. The strong pushback from governors, irrespective of their political affiliations, underscored the deeply held belief in state sovereignty and the legal limitations on presidential authority over state militias. This controversy serves as a potent reminder of the checks and balances embedded within the U.S. Constitution, particularly concerning the delicate relationship between federal and state powers. It highlights the importance of understanding these constitutional boundaries, especially when political rhetoric ventures into areas that could fundamentally alter the existing framework of American governance. The National Guard remains a unique institution, a symbol of both state autonomy and national strength, and its proper deployment is a matter of profound legal and constitutional significance.